As I'll indicate, all of the members of the board are present. We have one unappointed position, so there are 6 of us. I do have seven items of public comment. I won't read the details, but they are all submitted by email.
Well, either he did or I did.
The first is submitted on 7/8/2025 by Rachel Brunwald. The second, and that'll be made part of our record. The second is Jonathan Shuptar, submitted today, 7/10. No, I'm sorry, also 7/8. I have another submitted 7/7/25 by Peggy Collins. I have another submitted 7/7 by Jenna Eisenberg. I have another submitted 7/7 by Jerry Musher. Another submitted 7/8 by Aaron Seago. And another submitted 7/9 by Sue McRoy. All of those public comments do not relate to and are not part of the record of our hearing tonight or of our zoning case tonight. They are public comments addressed in connection with the Open Meetings Act rules, submitted in connection with the meeting that will include the hearing. So I don't even know the subject of these. Oh, I guess I read some of them and they do purport to relate to the petition this evening. But unfortunately, I've been instructed that the rules do not permit these items to be considered a part of the record in the case. So next we have the minutes of the Zoning Board of Appeals meeting of May 8th, and we have a transcript of those minutes, transcript of the proceeding, which will serve as the minutes. Then we have zoning petitions 25/021 meeting on May 29, 2025. Again, we have the transcript of the proceedings, which serve as the minutes. Then we have the zoning Board of Appeals June recommendation meeting of June 5, 2025, and we have a transcript of those. So can I take
a motion?
I second.
Motion by Mr. Moran, seconded by Mr. Murphy, to approve the minutes of those 3 meetings. Any discussion on that motion? All right, all in favor of the motion, please signify by saying aye.
Aye.
Any opposed? There are none opposed, and the motion passes. Then we have our recommendation session for zoning petition 25/035, the Hannah's petition of Milton Township. This is a request for conditional use to allow a video gaming cafe restaurant in a B1 local business zoning district, and a variation to allow a video gaming cafe restaurant to be located less than 1,000 feet from a place of assembly. Let's start with a motion on that case, and then we can go to discussion.
I want to make a motion to deny the variation on the with less than 1,000 feet, because I just don't think I didn't really agree with the.
Well, would it be a motion to deny the variation or both the conditional use and the variation?
That's
Kind of one follows the other.
yes, so it end up being denying both.
Okay,
I'll second.
motion to deny by Mr. Moran and seconded by Mr. Murphy. Now, discussion on the motion. Do you want to finish?
Yeah, I just the hardship, I just didn't see the hardship. We're looking at we're looking at a place of worship. I don't care if it's small or large, they're a place of worship. And it says they only meet on weekends. They could grow. And it's closer than 1,000 feet, so I just didn't think it was a hardship. That's what I saw.
Any other remarks, Mr. Murphy?
I'm gonna vote no on this, basically because it affects the neighbors, it affects the values of their houses and everything there, and they've been there for years. And we should take that in consideration.
Just to clarify, when you say you're gonna vote no, the motion is to deny, so you're gonna vote yes. But you're
I'm gonna vote
trying to
to
convey
deny
you
it.
oppose. Yeah, okay. Mr. Jared, did you want to make a remark? I saw you.
Yeah, I was just agreeing with you, what you said earlier about the standards and for the variation, they're not demonstrated with the 1,000 feet and below, so.
Yeah, I think it would be very difficult for us to start to parse the 1,000-foot requirement based on the level of activity of whatever use is within that 1,000 feet, which is essentially agreeing with you that we shouldn't consider the size of the church. And for the record, if we deny the variation, I think we necessarily have to deny the conditional use, because the conditional use can be denied consistent with the living word standard if there's something unique about this particular parcel within the district. Well, the uniqueness is this parcel is within the 1,000 feet of the place of assembly. So that's my 2 cents. And then would you call the roll on the motion to deny?
Member Moran,
Aye.
Member Murphy,
Aye.
Member Gerard,
Aye.
Member Ramon.
Aye.
Member Schultz,
Aye.
Chairman Kurthoff.
Aye. Motion to deny passes by a vote of 6 in favor and none opposed. And we'll transmit it to the County Development Committee. I don't know, there's a lot of people here for a recommendation meeting. Not sure, are you folks here just to find out what's going on with the case that we just heard?
Yes.
Okay.
Thank you.
Mr. Lukens.
Thanks.
Now, the next item on the agenda is consideration of the new rules. That is an action item. It's also old business because we considered it before. Let me just start the discussion by saying that Mr. Schultz made an observation when these were first distributed. And that observation was that there is a pretty fine line and difficult to understand distinction between the acting chair and the chair pro tem. I looked at that after those remarks, and frankly, I clearly agree. I don't know how all of you feel, but I would suggest a revision to this draft in which we collapse acting chair and chair pro tem and just have chair pro tem. And I jotted this as the rule: a chair pro tem from the existing ZBA membership. I'm tracking pretty much what's in here. A chair pro tem from the existing ZBA membership may be designated by the chair to serve in the absence of the chair during the chair's absence, disability, disqualification, I'm adding, or recusal. In the event the chair fails to so designate a chair pro tem in the foregoing circumstances, a majority of the membership may do so. So in other words, this was apparently intended to say, well, sometimes the chair will appoint an acting chair if, you know, if something happens. But if the chair doesn't do it, then the members can do it. And we just have two different titles. So, you know, acting and pro tem, et cetera. So that's my 2 cents worth to resolve the issue that Mr. Schultz raised. I have texted that language to Jessica, so if you guys agree with that concept, we can look toward that, or look to that as a possible revision to these rules. Now, let's open it up. Does anyone else have any comments about the rules? Carl, you want to add anything to my,
No, you know, that covers the thing. I mean, it clarifies that there's the ability for the board to act
Yeah.
in the chairman's absence
Right.
if it's unbeknownst prior, so. I think. it covers everything.
I also looked at the definition of quorum because it's, we have an issue of establishing a quorum when a member is not appointed. And it's my belief that a body like ours can redefine quorum to consider, let's say, a majority of members who appear, counting that number of those serving even in the event that one spot is vacant because an employment hasn't been made. So if Mr. Jones was absent from a meeting, you establish the quorum by the majority of 7. But if Mr. Jones' former spot is vacant, you could define it otherwise and have a lower number for quorum. And while I was first tempted to consider that, I thought, well, how low do you go then? How do you determine how many spots can be vacant or whatever? So it just seemed to me that it's the county board's responsibility to fill the vacant spots, and we should leave the definition of quorum alone rather than try to tinker with it in the unlikely event that there was a long-term vacancy. And if there is a long-term vacancy, we can just deal with it.
And
So that's the only other update that I had to these. Anybody else? If not, we just need a motion to approve them and then they're done.
I just have a quick question. The first attachment is the affidavit for the person that takes a petition amongst their, it's at the very back page of the
Yep.
handout. So my question is that, you know, this is the affidavit of me. I went around and I took signatures from everybody. Is there anything, I couldn't quite take it out of the context. Is there anything that is a requirement on the petition itself? Does it just need to say the issue and then have as many signatures as possible as long as I attest to it?
I don't understand that question.
Well, my question is that like, this is, the thing that's here is what I signed as the person that received the petition.
Circulating the petition.
Circulated petition. The other page has all the names on it, presumably it has some kind of title as to what
Yeah,
the petition's about.
right.
Is there any other requirement to that?
Well, I don't know. We could do that at some point in the future, but frankly, they come in such varied forms. This is just, you know,
Okay, well, I just,
rough shot at.
yeah, I don't really, I'm not a lawyer and I'm not a,
Yeah, Paul, you
maybe I
wanna
just
add
wondered
something
if
to
there's
that?
anything.
I just want to be clear here. Are you talking about attachment A,
Yeah, one,
attachment 1?
Yeah.
So the zoning board of appeals rules, well, inure to both the zoning board of appeals and the zoning hearing officer. So this attachment is, what we use in the zoning hearing officer program, if that helps at all in terms of your concern.
yeah, well, I just
What do you
was
mean? I thought
wondering,
this was what Carl said. When you circulate a petition, you need that certification from the person. This is the notary requirement.
Okay, fair enough. I understand. Okay.
Yeah,
Okay.
you know, it's not necessarily, I feel like we need to do something, I just want it to be clear. If there's some requirement that we had beyond me saying that
Maybe we should write more reasonable facsimile beneath this.
okay, that's fine, it's, was just
You know,
a,
because we're gonna accept them if it's within,
anything reasonable,
yeah.
okay. All right,
Is that right, guys?
Yeah, that's fine.
Are
That's
we
a good
missing the
statement.
vote here?
Huh?
Are we missing something?
No, no, we're fine.
Okay, where does this refer to in the rules? Attachment 1.
Well, attachment 1, and to be clear, and I don't want to confuse the matter too much, but attachment 1 is what we are having you sign, essentially adopting the document.
Adopting the rules?
Yes.
Oh, so this had nothing to do with the petition?
Right.
Okay.
Oh, okay, well.
Is that a fair statement?
Yeah,
Okay.
yes,
But now that it was
Well, then
brought
why
up,
does it say with respect to ZBA petition number?
Well, it's, that's a good point. It should really be relative to these rules of procedure.
Okay, we'll fit.
Yeah, we'll fix that.
You make the adjustments to that.
Yeah.
Now, that begs the question then, do we need a form? Because we always tell people, you circulate a petition and you have to have the signature of the person who circulated sign, and I often scribble in, I, Joe Blow, certify that I circulated the petition and the people who signed the petition signed in my presence. Then my signature is notarized, not everybody that signs the petition.
well, I just want to
Well, you raise
clear
another good
myself and
point.
be clear, because we're not trying to fool anybody, we want to be straightforward, right?
So there are many, many documents that we have for petitioners to fill out and work on that are apart from the rules of procedure. The document that you're referring to is something that we do provide to the petitioner along with other documents that have nothing to do with the rules of procedure. We can share that document with you to make sure you're comfortable that it is consistent with what we have historically asked for a property owner or an objector to a petition to fill out, but we don't think it needs to be in the rules of procedure.
Fine.
That makes
That's
sense.
fine, yeah,
So-
perfect.
But I'll
we
get you
can
that,
accept anything then?
pardon me,
We can accept anything
the,
if they don't follow? the
If it's not in
rules?
the,
it's not in the correct format.
put differently, how can we reject it if it's not in the rules? How can we reject one person's petition and say, well, you didn't follow our procedures?
So that's a good point. Toward that end, we can provide you, we can amend this rules of procedure to include that document and include a very specific petition format for people to follow and essentially say, in the rules of procedure, if you don't follow this document, then it will not be accepted.
Do people normally ask you, Paul, how to?
Yes.
Okay.
Yes.
Actually, we don't really have a problem with this for the last 10 years. Because people because frankly, we bend over backwards to say, here, you gotta sign this that I write on the bottom. Go ahead.
I can tell you historically that we have had issues, and we've learned from, not our mistakes, but we've learned from issues where we provide a great deal of documentation in letter form to the petitioner up front. You may have heard the chairman say from time to time, did you receive this document, the staff that says, here's your proof of it? And we send that to them, we get them to sign it, and they're like, oh, that's what that document was. So we've learned our lessons, and one of those lessons is that we provide the actual petition. And when we go over the petition and how to sign it, how to fill it out, how to do it individually, how to do it as a petition where you are getting multiple signatures and you at the bottom are notarizing it as the person who's circulating the petition. So we've got a lot of documents that provide all that information. We just didn't think it needed to be in the rules of procedure, but like I say, if you want it to be in there, you can put it in there so that it allows you to say, if you don't follow this format, our rules of procedure say we can reject it. You want to
Well,
belt and suspender it.
Let's get to the bottom line. Rules of procedure only exist in the face of a possible dispute as to any of these items. I mean, once you have rules, you throw in things like establishing a quorum. But we don't need any rules. We can wing it day to day unless we think there's gonna be a problem with something in the future, and then you need rules to fall back on and say, you can't do that because it's not consistent with the rules. Now, having said that, and it occurred to me to say that because of what Paul said. You know, we give them the paperwork and, we don't have to treat everything in these rules because this isn't a problem. So I don't think it needs to be amended. What?
Yeah, it's our position that it doesn't need to be because it is one of those documents
Yeah,
that we hand out anyway.
yeah, fine,
It's part of our normal course of action. That's part of the zoning board of appeals thing.
right, fine. All right, so let's,
But sorry, Mr. Chairman, but to be fair, we will give that to you to show you what we're handing out.
Okay.
So that you have an
But
understanding.
we can still accept something that they did, not with your paperwork, if it's legit, they.
we can do whatever we want.
That would be a decision of the chair and the board.
But here's the trouble, if we stray too far on a case-by-case basis, it creates an issue that could be taken on administrative review. And if a judge says, you know, not really a material problem, your lawsuit is denied. But if a judge says, yeah, you guys, you're all over the map. Like Judge Paulmeyer said, oh, you helped this petitioner, but you didn't help Scott Day. So therefore Scott Day wins. Well, that was, I swear, I know that judge. I've appeared before that judge many times, and that's the most bizarre thing I've ever heard her say. She should have attended some of those hearings with Scott Day. But that's another matter. Geez, I forgot I was being zoomed. Oh, well.
You guys not practicing.
Judge Bowles, well, neither am I, so moving on. All right, so let's vote on this.
Yeah.
Somebody make a motion.
I so move.
Mr. Murphy moves to approve.
I'll second.
Mr. Moran moves, seconds the motion. Any further discussion on the motion? All in favor signify by saying aye.
Aye.
Any opposed? Rules are adopted. Thank you, thank you. You might as well stick them in your briefcase, by the way. Oh, you'll fix up that one with and then redistribute?
Yes.
Fine. Just bring copies to us at some future meeting.
Old business and new business.
Well, I thought that was old business. Okay, so there's no further old business, there's no new business, and we're ready to adjourn. We are so adjourned.